Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back to Legalese 123. I'm your host, Missy K. I hope everybody is doing well on this Wednesday, November the 26th. I think winter is upon us. We got that S word last night. Just a little bit, a little dusting, a little sprinkling. So, it's going to be one of those winters, huh? I hope you're doing well. Did you get your turkey yet? Is it a fresh turkey? If it is, you're great. If it's one that needs to be thawed out, I hope you have it out of the refrigerator and ready to go. Hoping that you are having safe travels and that you make it to your destination or that you have a wonderful time with your family. So, happy Turkey Eve. What do we got going on today? What are we going to talk about today? Well, you're not going to believe it. But apparently, last night at 11:30 p.m., Robert Cosgrove, who is the special prosecutor for Aidan Kearney, dropped a bomb. Yep, he finally responded. How and why and how is this possible? Who knows? It's Massachusetts, where it's the upside down crazy world where you could just go ahead and file things at any point in time and it doesn't matter. Really. It doesn't matter that, Aidan Kearney's life is in the hands and that, he's spending all of this money with his lawyers trying to defend himself. Doesn't matter. Timelines, deadlines, receipts, that doesn't matter. So, guess what we're going to go over today? We're going to go over the response that Cosgrove has placed. But before we do that, some people don't know about this case. And by the way, welcome to my new subscribers. I'm so happy. I believe at the time of this recording, I had 46 members or subscribers. So please like and subscribe. I'm trying to get to 50 before December 13th. I have a holiday party I'm going to. I need to kind of explain what it is that I do because people just don't know. Again, I got involved with this because when I was talking to people about the Karen Reed case, they're like, who's Karen Reed? Can you believe it? There are people out there who don't know who Karen Reed is. There are people who go about their normal days who don't care about any of this stuff. But I'm here to give you the breakdown. So, as a reminder, Aidan Kearney, his nickname is AKA Turtle Boy. This is Robert Cosgrove. This is the person who is going to respond. This is Ken Mello. Okay, so who is Aidan Kearney? Aidan Kearney is an award-winning journalist. He is a blogger. He is a YouTube personality. He goes on YouTube and does presentations about things that he has discovered, etc. He has broken some major cases in Massachusetts. He got involved with the Karen Reed case right before her very first trial. Who is Karen Reed? Karen Reed is right here. Karen Reed was the girlfriend of John O'Keefe. Karen and John had gone out to a couple of bars that evening, met up with some other people. They were going to continue the party at 34 Fairview in Canton, Massachusetts. John and Karen leave. They go to 34 Fairview. They've never been there. They're not really, really good friends with the people inside the house. John O'Keefe is a Boston police officer. Something happens to John O'Keefe in the early morning hours of January in 2022, I think. Anyways, don't quote me. I'm just giving you the gist of it. Long story short, John ends up dead. He's on the lawn at 34 Fairview. Who killed John? Well, Karen Reed has been tried twice. Prior to her first trial, the federal investigation was going on. The FBI was investigating something. We don't know. We know that there was a federal grand jury convened, which means that people came in and testified in front of the federal grand jury. As to what they were trying to do, we don't know. We don't know if they were investigating the Massachusetts State Police. We don't know if they were investigating the district attorney's office in Norfolk County. We don't know who they were searching for. But what we do know is that everybody pretty much who testified in Karen Reed's first trial first testified in this federal grand jury. And in this federal grand jury, we realized a whole bunch of information. One, Trooper Michael Proctor, who was the lead investigator in Karen Read's case, had inappropriate text about Karen and had a bias for her from the beginning, basically stating that he believed that she had committed this crime and he was going to do anything and everything he could to pin it on her, to make sure that she was convicted of killing John O'Keefe. The feds also hired a accident reconstructionist, the AKA crash daddies, right? The feds hired them to recreate the crash to find out whether or not Karen Read had actually killed John O'Keefe with her car, or whether or not it was something or someone else, right? And in their recreation, they came up with the notion John O'Keefe wasn't hit by her car. His injuries aren't consistent with being hit by a car, and the physics don't lie. But did that stop the Commonwealth? No. They not only tried her once, she was acquitted. There was a mistrial the first time. They tried her twice. So in 2023, they tried her. 2024, they tried her once. And in 2025, can you believe it was just about 6 months ago that she was acquitted? And a lot has happened since then, right? So how does Aidan Kearney come into this? Aidan Kearney started doing posts and reviews and getting the word out about Karen Read and the injuries to John O'Keefe, and making the claims that Karen Read did not kill John O'Keefe. He got a lot of backlash from that. All of the witnesses are like, she killed him. She did. I know she did. And so then he got supporters that have the Free Karen Read movement. And in that, he started calling out the witnesses in Karen Read's case. He started calling them murderers because the narrative changed. Karen Read's team said she didn't do it. And his injuries are consistent with possibly him being in a fight. He has dog bites on his arms. The owners of the house had a dog. Did the dog do something and hurt John O'Keefe, and that's how he died? Did he get into a fight with one of the people inside the house and he fell back and he had a big gash on his head, and that's how he died? We don't know. We don't know it. We do not know if those questions will ever be answered. But boy, they are fighting hard to find out. So Aidan Kearney starts reporting, doing his investigative journalist interviews, etc., starts going on YouTube and talking about all of these witnesses, etc. And in that, he's used a lot of colorful language to describe the what we now call the House defendants. He actually goes out and calls them murderers. He went out on a rally where he went to each one of these people's houses and had a megaphone and had people going out and following him and like parading around the streets calling these people murderers. Is that right? Is that wrong? Is it free speech? You be the decider. So Aidan Kearney is currently right now has a whole bunch of charges against him for witness intimidation. And this was in reference to Karen Read's both of her trials. So he's got a lot of people that were testifying in the trials, and that they then felt intimidated. Honestly, are you really intimidated? But here we are. It has come to light that it's possible that the people that were involved, as well as the special prosecutor and the district attorney's office, and when I say special prosecutor, I'm talking about the very first one, Ken Mello here. Remember, Ken Mello, let's back up. The district attorney's office in Norfolk County could not prosecute Aidan Kearney because there's a conflict. So people in the DA's office, the prosecutors there who are on the payroll, couldn't prosecute Aidan because of a conflict, or maybe they didn't want to. So they hired somebody else. They hired somebody who's an attorney outside of the district attorney's office. And so the first one was Ken Mello. Ken Mello is being accused of conspiring against other people and witnesses to AKA get Turtle Boy. And what I mean by that is, you're like, oh, in this day and age, you would like to have evidence and you would like to have people say that you've committed a crime. What evidence do you have that he committed a crime? What evidence do you have that he did this witness intimidation? And it's come to light that maybe some of the evidence was fabricated between witnesses, other people that are coming up, etc. And Ken Mello is completely drugged through this, as well as a couple of police officers. Brian Tully and Yuri Buchanan are the two to be named in this conspiracy. Ken Mello gets sick, so the case just lingers, right? They brought on Robert Cosgrove. This is Robert Cosgrove right here. He then now picks up the case. And again, the Commonwealth is doubling, tripling, quadrupling down to get Aidan Kearney, and they also are conspiring to try to get Karen Reed as well on some other charges. They just can't leave well enough alone. I talked about this before. Prosecuting attorneys need to make sure that they're doing it for the right ethical reasons, right? Are you charging someone because you have evidence they committed a crime and therefore they need to be prosecuted? Or are you just doing it out of spite, out of revenge? You don't like what Turtle Boy has to say? We're going to go ahead and put some charges on him, see how this goes. And again, there's no urgency in the Massachusetts state courts. Things can just linger on for however long. And we talked about this in the last stream. When is enough enough? When do you finally just say, okay, this case has got to move along? And on top of it, I mean, this sandwich is building and building and building. On top of it, they've had different judges. First, they had Judge Doolin. We talked Judge Doolin got moved to civil court. Now they had Judge Krupp. Judge Krupp is like, okay, let's get this case going. Judge Krupp magically disappeared. We don't know how or why. There's been no notification as to why Krupp is no longer the attorney on this case, or the judge on this case. They got a new judge, but nobody told them why. It's like, it's bananas. Again, when I tell you these stories, I'm not making this stuff up. I can't make it up. It's here we are. So again, Robert Cosgrove was supposed to respond to the mega motion filed by Aidan Kearney's attorney, Mark Betterow. Mark Betterow made this big motion to dismiss. And again, more information is coming to light. There's discovery issues. Discovery is where the prosecution is supposed to give the defense all of the evidence that they may or may not bring in, and that it is the defense's job to go through this evidence and say, nope, this can't come in. Nope, what is this? And be able to confront your witnesses, right? Aidan Kearney is innocent until proven guilty. He has the right to confront the witnesses who are saying things against him. He has the right to confront his evidence and state whether or not this evidence is true or not, right? So, Mark Betterow had filed a motion to dismiss. The prosecution, which is Robert Cosgrove, has the opportunity to respond. There was an initial date in October for him to respond, and he said, it was called the mega motion for a reason. I forget how many pages it was. It was very, very long. Robert Cosgrove said, hey, I'm an old man. I need more time. The court gave him more time. He had until November 17th to respond. Did he respond? No. Did he make any communication to the court that he couldn't respond? No. Did he make any notification to the defense and said, I need more time? No. And guess what? Last night at 11:30 p.m., he files his motion. Is that fair? No. Is it right? No. Does it matter? No. The court doesn't care. Might he get like an admonishment? Oh, you should have done this beforehand? Maybe, but there's not going to be sanctions. He's not going to lose his bar license. It's the upside down, just do whatever you want world in Massachusetts. So, unfortunately, it's Thanksgiving, right? And Mark Betterow and Tim Bradel aren't going to look at this motion. They're having time with their families right now. The mega motion or the motions to dismiss are due to be argued in court on December 5th. Will that happen? I really, certainly hope so. Again, this case has just been lingering for several years now. And it's, to be honest with you, it's wrong. So we're going to go over the motion. Yay! All right. So here it is. Bear with me for just a second here. I tried to make this bigger. Again, I'm trying to make it bigger so you could read it, but that might not happen. All right. Well, here we go. This is the Commonwealth versus Aidan Timothy Kearney. This case is specially assigned to Judge, let's see if I can pronounce his name, Belezos. Hopefully that's good enough. This is the Commonwealth's memorandum to oppose Attorney Bettero's affidavit in support of motion and associated submissions. The defendant has filed a group of documents supporting an unfiled motion or motions, most notably what is effectively a motion for reconsideration of the denial in large part of the defendant's previously filed and decided McCarthy/Odell motion to dismiss. Wow. If that's not a word salad, I don't know what is. I don't know what Cosgrove's trying to say there. Attorneys. The present defense documents include attorney Mark Bettero, affidavit in support of motion, various exhibits, about 55, memorandum. Oh, he's just like, oh, okay, I see what he's doing. Your Honor, I haven't replied to any of these motions or anything like that, so I'm just going to go ahead and just throw it all in here in the salad, and good luck. And I'm also going to just say, like, hey, there's this and that, and I'm going to be a little snarky to begin with. Functionally, it is difficult to distinguish the Bettero affidavit for a memorandum of law, although it's oh my gosh. Okay. Again, this is what we like about motions, right? We get the snark, we get the sassiness because you can put anything in a motion, right? And here he is calling out Mark Bettero. It's difficult to distinguish the Bettero affidavit from a memorandum of law, although it also serves the function of informing the court of what unfiled motions it is reporting. In a brief, the defense seeks outright dismissal of the pending indictments pursuant to the Commonwealth versus Odell, or alternatively, an evidentiary hearing in support of that aim. Dismissal of the indictments for the Commonwealth's alleged failures in providing discovery. Duh. Disqualification of Special Prosecutor Ken Mello. Yeah, because each time they get something new, they file another motion to be like, hey, and there's this, and there's this. Again, the sandwich just keeps building and just keeps building. After setting forth these aims, the Bettero affidavit first lurches into a section entitled Background, which is essentially a hieroglyphic, I'm assuming that's hieroglyphic, hierographic portrait. Oh, that's a great word. Of the defendant as crusading, heroic journalist, fearless pursuing the truth, exposing the falsehoods of the Commonwealth's witnesses in the Karen Reed case, laying bare the corruption of local and state police. I can't read that because the stamp is over it. Existing the attempts of the forces of evil, aka the Norfolk County District Attorney's Office, to deter him in his courageous and never ending battle for the truth, justice, and the First Amendment. I couldn't have said it better myself. I think that's great. I think that's exactly what he's doing. Good job, Cosgrove. Give you a round of applause for that. How are you going to counter this? And reading Bettero's, oh my goodness, we're getting the big word salad here. And reading Bettero's Economus, I don't know, to Saint Kearney. Oh, he. Oh my gosh, this is great. I have to write this down. It is Saint Kearney. Oh my gosh, that is great. Oh my gosh. That is this this is great. Okay. One is irresistibly reminded of Oscar Wilde's comment on the death of Little Nell, the virtuous child in Charles Dickens' The Old Curiosity Shop. One must have a heart of stone not to laugh. The Oh my goodness. The Commonwealth has had occasion to respond to such drivel in the past with some reluctance, now does so again. Rather than reinvent the wheel, it quotes liberally from its response to the defendant's previous motion to dismiss. Defendant Carney is self employed, supporting himself via a variety of internet presentations, appearing on such outlets as YouTube, Facebook, X, his broadcasts quite frequently, at least 4 times a week, and has monetized his productions in various ways, including selling subscriptions, begging online for contributions, selling t shirts, etc. He attempts to present himself to the viewing public, much as he seeks to portray himself to this court as an investigative journalist, reporting on matters of public concern, who often break stories by conducting investigations into matters neglected by law enforcement before viewers' very eyes live on the air. The crusading journalist pose is supplemented by assertions of virtues, moral outrage, fearless in the face of opposition, crass vulgarity, as seen, for example, in the opening to his YouTube shows, which begin with an extensive repeated chant of, "I'm going to blank you up." The indictments against Carney at issue, okay, the the quote, "I'm going to blank you up," is a direct quote from Colin Albert that was then testified in Karen Reed's first trial. So he's not saying that. He is repeating a phrase. Oh my goodness. The indictments against Carney at issue in the defendant's original motion to dismiss largely, perhaps entirely, grow out of his activities connected with the Karen Reed case and its witnesses. In footnote 1, a subsequent set of indictments against Mr. Carney named a former paramour, Lindsay Gattani, turned informant for the Commonwealth, Lindsay Gattani, as an alleged victim. Those indictments have since been dismissed by the Norfolk DA's office. Right. So Lindsay Gattani was a former paramour of Aidan Kearney. He got indicted on a separate charge in reference to her against a domestic situation. She has later since come forth in saying that she didn't want to go forward with that it was she was coerced by witnesses in the Karen Reed case or the other parties who I'm going to call people out to get Aidan, former employees, and another person with whom Aidan Kearney had um, called out for being being in the Massachusetts State Police and having involvement with a drug ring, people who are out to get him. And again, it's evident in some of the discovery materials that they've received that these people are out to get him. Okay. Reed has pleaded not Reed has pleaded not guilty to the charges of second-degree murder, manslaughter while operating under the influence, leaving the scene of the motor vehicle accident after personal injury that resulted in death. And she was acquitted. As recently summarized in the press, the Commonwealth alleges that Reed backed her Lexus SUV in a drunken rage into her boyfriend, Boston police officer John O'Keefe, on early January 29th, 2022, after dropping him off outside a Canton home following the night of bar hopping. Anderson Anderson Travis, I don't know who that is. Prosecutors oppose motion to dismiss charges against Karen Reed, call allegations of evidence tampering baseless. Boston Globe. Okay. The defense claims that Reed was framed and that O'Keefe entered the house, owned at the time by a fellow Boston officer, where he was fatally beaten in the basement and possibly attacked by a German Shepherd before his body was planted on the front of the lawn. Okay, so yeah, that's the narrative that Karen Reed's defense team was putting forth. And Aidan Kearney just was reporting on that. See, something that people don't understand is that since the advent of the internet, journalistic standards and journalistic ideology has changed. People are no longer reading the newspaper. People read things online, right? People aren't watching the television. People don't really go and look at the news stations anymore. Young people get their news and information from YouTube, Twitter, or X, Snapchat, uh, Instagram, TikTok, right? We're of the TikTok generation. That's where they get their news from. So if you're reporting on something or you have something that you want to share, those are the outlets that you share it with. Mainstream news media is dead. Okay, all all that he is doing right now is just reiterating things. He is not really responding to the motions per se, because in your response you have to say, okay, I don't agree with what you're saying here, and here's some case law that goes back to this. He's just reiterating things. He's not even making a point here. But we're going to continue to read. At some point early in the Karen Reed prosecution, on or about April of 2023, Kearney made her the subject of some of his online presentations, apparently drawing a favorable audience response. Duh! When you have a sensationalized story that a person was killed on the lawn and he has dog bites on his arm, he has a big gash in the back of his head, you're like, how did that happen? He wasn't hit by a car. He has no broken bones on his body. He has nothing that's indicative of a car being hit by a car. And even the medical examiner, the cause of death is unknown. So why can't somebody report on that? Why can't people say, hey, this person died? And why can't he investigate? Nobody says he can't. And he did investigate. He found a couple of things that he gave to the defense. He found Lucky Lochran, who was the snowplow driver. The police were not doing their job. And it is proven that Michael Proctor had a bias against Karen Reed. He has since been fired because of that. And that is well documented. So if you say that some of Kearney's information isn't factual, it doesn't have to be. It's his YouTube presentations. He can do whatever he wants. He can say whatever he wants, just like I can say whatever I want. It is a First Amendment right. And that is what's at issue here. First Amendment. You have the right to say what you want. I'm going to continue on. One person who took note was Natalie, who attended Bentley College with Reed in 1998. Oh, that's right. Okay. To 2022 and was living in California. In February 2022, Natalie saw news articles about Karen's arrest stemming from the death of John O'Keefe, prompting her to contact Reed and offer support. Two women began an ongoing series of conversations covering a number of topics, among them Reed's alleged innocence. She was proven she didn't do it. Reed sent Natalie pictures of Colin Albert and suggested that he and O'Keefe shared mutual animosity. In April 2023, Natalie spoke with a Facebook supporter of Reed who told her she had a friend, Kearney, who would be willing to cover Reed's story. Natalie asked Reed if she would be interested, and she was. To facilitate communication about the case, Reed instructed Natalie to download a message app called Signal, which auto-deleted messages after a certain period. So what? So what? Reed is not guilty. And besides that, she's innocent until proven guilty, right? She can do whatever she wants. It's not against the law for her to go on Signal. It's not against the law for her to talk to people about her case. The woman is fighting for her life here. Natalie assumed the role of the go-between Reed and Kearney. With Reed sending her information and pictures, Natalie pasting it into text messages for Kearney. Prove it. Prove it. Show me the documentation. Natalie stated that these text messages included information regarding witnesses, the home addresses of Trooper Michael Proctor. You can go look up Michael Proctor. Come on, people. I can Google Michael Proctor right now and find his address. You can Google anybody and find their address. It's not that difficult, people. That's not a crime. It's not a crime. Pictures of witnesses, autopsy photographs, motions filed by her attorneys, police reports, photographs taken by MSP, crime scene services section. Okay, prove it. Show me what they did. In short, Reed passed along through Natalie everything Kearney would need to act as a press agent for Karen Reed while feigning the role of a crusading investigative reporter. Um, that might be true, but he also got a ton of information from the public. You know why? Because the public trusted Kearney with the information. You wouldn't believe how much stuff is funneled through him. You wouldn't believe how much stuff he gets that he doesn't report on. Does he actually have to go through and investigate whether or not this information is true or not before he states it? No. Does he always? No. He said that himself on many of his presentations. Okay. Tell me where a crime has been committed. I still don't see anything that's wrong. Okay. Reed would sometimes point out mistakes in Kearney's blog presentations to Natalie. For his part, Kearney would ask questions about court paperwork, which Natalie would forward to Reed, who would respond to her. Reed and Kearney took pains to conceal their relationship for the public. Who cares? She would sometimes send him information but tell him that he could not put it over the air. Okay. Typically because it was information that had come through her discovery, which was not public. Use the information. Okay, how is this witness intimidation? How is witness intimidation? And an observant follower of Kearney's, such exists that she was feeding him information. It is also clear that Reed enlisted the cooperation of counsel in coordinating her information dumps to Kearney. Lieutenant Brian Tully's testimony provides a telling example. In mid-May, Kearney sent Natalie a picture of himself wearing a t-shirt depicting a Google bar with the phrase, "How's long to die in the cold?" a reference of a piece of evidence in the Commonwealth versus Reed. Natalie responded, she'll ask Reed if he can wear it to court. Natalie later tells Kearney, quote, "It's okay to wear that t-shirt. How's long to die in the cold? I got the okay." You asked Alan, an apparent reference to one of Reed's attorney. Natalie replied, "Absolutely." Kearney wore the t-shirt July 25th, 2023. How is that wrong? Because in their court filings, when they went to court and stuff, in motions and stuff, that are public information. Okay. Again, I don't see anything to your opposition into the motions. In early June of 2023, the two women had a falling out. Natalie had provided some encouragement and advice to Kearney over a proposed documentary. Upon learning of it, Reed became angry. An argument ensued, and the two women ceased to speak to one another. Natalie was aware, however, that Reed also communicated with Kearney through John Silva, and Natalie herself had provided Reed with Kearney's Signal username so she could contact him directly. Grand jury summonses issued to Verizon requesting call detail records for two of Kearney's phone numbers and the phone number Natalie provided investigators for Reed. The resulting records showed 189 calls between these numbers, totaling over 40 hours. Kearney continued to lie to the public about his cozy relationship with Reed, denying it in August of 2023. A video that he was communicating with her or her lawyers. Obviously, the telephone was not the exclusive means of communication, as the two were communicating through Signal. Prove it. The defense, as it developed the first Reed trial, as previewed by Kearney's statements and action as it unfolded in court, was something of a murder on the Orient Express defense. Everyone in the O'Keefe's home on the night in question, as well as the investigating officers and either murdered John O'Keefe or was complicit in the cover-up and framing of Reed, who was innocent. Yeah, she was acquitted. So who killed John O'Keefe? At a grand jury could have concluded from the evidence before it pushing this theory, Kearney attacked virtually every prosecution witness, including all people present in the house that evening, as well as certain other family members. He also savaged O'Keefe's family members for their support of the Reed prosecution. In addition to his verbal attacks, the defendant harassed many of the witnesses by means what he called a rolling rally. He went on the streets and protested. It was a protest, gathering a caravan of his followers to drive to the homes of the witnesses where he denounced and taunted them with a megaphone, often exhorting them, tell the truth. How many times have you seen reporters camped out at somebody else's home and yelling and shouting things at them? Gabby Petito, for example, they went to his home and were camped out there for days trying to tell them what's going on. In the recent case of the little girl who was missing, her mom took her to Utah somewhere. Where is she? They're out on her lawn. Hey, hey, where is she? Where is she? Okay, argument. Having previously brought and fully litigated the McCarthy-Odell motion, the defendant has no right, no right to bring a renewed attack on a grand jury proceeding already upheld by this court. Oh, well, they're bringing that up because new evidence has come to light that maybe you had presented fabricated evidence to the grand jury. And so, why not? Arguments he previously raised have been considered and decided and are settled. Arguments that he failed to raise but could have are waived. That's not how this works. On February 14th, 2025, the defendant filed his McCarthy-Odell motion to dismiss indictments for lack of probable cause and the prosecutor's impairment of the integrity of the grand jury with misrepresentations of fact of law. At the time he did so, the Commonwealth had provided in discovery to the defendant all the grand jury minutes. Among other things, he thereby necessarily had full and complete knowledge of the following. Well, we know for a fact that Massachusetts is terrible at turning over discovery to attorneys. It's like dated back to the ages. Remember, I told you, go watch Trial 4. Rosemary Scapiccio is helping Sean Ellis. And even in the end, he's getting ready to go for his fourth trial. I kid you not. I cannot make this stuff up. He's getting ready to go to his fourth trial. And lo and behold, there's still discovery issues after 30 plus years. WTF. If you're not saying WTF to yourself, then what? So guess what? There's discovery issues in this case as well. They're still getting stuff. It's crazy. So how is the defense supposed to respond? This hasn't gone to trial yet. We're still in the motions phase, right? So currently right now there's been no real big harm to Aidan Kearney because he hasn't gotten all this discovery, or they're finding out this discovery right now. Remember in Karen Reed's case, oh, no big whip, the video is inverted. Oh, you're getting piecemeal. No harm, no foul. She gets another trial. People's rights are being trampled on left, right, and center in Massachusetts, and I cannot wait. I cannot wait for these lawsuits to come back. I think it's called like a 1983 lawsuit where you as a defendant can sue for malicious prosecution. Can't wait. All right. At the time he did so, the Commonwealth has provided in discovery to the defendant all the grand jury minutes. Among other things, they thereby necessarily had full and complete knowledge of the following. That the grand jury heard Special Prosecutor Mello ultimately did not ask the grand jury to return an indictment against Kearney for illegally wiretap. That is not a defense. This is not a defense to the motion to dismiss. Oh, Mr. Mello didn't seek an indictment for wiretapping. So I don't know what you're complaining about. This still should go through. There's no reason to have a motion to dismiss. All of the testimony of the grand jury witnesses, including Detective Lieutenant Tully. He's lied. We're going to see Tully. All of the instructions given and or not given to the grand jury by Mr. Mello, and all questions, comments made by him. All excerpts of Kearney's online media presentations introduced into evidence and how they were identified on the thumb drive introduced to the grand jury exhibits. Okay, well, that's a problem, right? Because it apparently the titles were altered to make it believe or insinuate that Carney was targeting these witnesses. Now, whether that's true or not, we're not sure. That's what the his defense team alleges. So we're not 100. We as a public don't have complete full information into that, but that's what's being told to us. So I'm curious to find out how that's going to come in. Carney originally told this court that the prosecutors impaired the integrity of the grand jury, misrepresenting facts and law, soliciting opinion, and distorting the state of the evidence by selective omissions. Duh. He specifically argued that Mr. Mello's instructions to the grand jury were deficient and that he elicited improper opinion and hearsay. However, he did not bother to raise any argument concerning the absence of the wiretapping against Scallion was a victim, and neither did he complain about the accuracy, completeness, editing, or titling of the video excerpts introduced as exhibits. They didn't do it at the time because they didn't know. They didn't know. They found out later that that is what had happened. Undersigned counsel filed a responsive mode memorandum addressing Carney's argument. On May 19th, 2025, having the benefit of both parties' memoranda, copies of the grand jury minutes, and copies of the online excerpts played for the grand jury by the Commonwealth, the court, Judge Doolin, issued a comprehensive decision allowing the motion in part, dismissing 6 indictments as presenting insufficient evidence, primarily those the named troopers as victims. So that's what they did. They did a motion to dismiss early on, and the troopers were also being in the indictment for witness tampering, and those dismissals got charged. Neither party moved for reconsideration. Neither party sought interlocutory appeal. Now the defendant wants to do it all over again. Yeah, because they found more discovery that would say that Ken Mello, Brian Tully, and other witnesses are colluding together to get Aidan by fabricating evidence. Duh! But where's your response to that, Mr. Cosgrove? Writing on Carney's behalf, Attorney Betterow has made the same arguments, having adduced various examples of alleged sins committed by Mr. Mello. Some of the same is presented by Attorney Bradel in the first motion to dismiss. He plucks a few different examples, but all of them were readily available in the support of the defendant's position in round 1. As justice of this court has aptly put it, a motion is not a dry run or a dress rehearsal to come back once an adverse ruling is obtained to try and do it all over again. But if you find more evidence of this collusion, guess what? You get to ask for it again. Not only that, they're also asking for Cosgrove to be taken off of this case, as well as Mello, because Lindsay Gattani is a witness in this case as well. Lindsay Gattani is a witness, and that other case got kicked off because she was suing everybody. So, just FYI, Lindsay Gattani was the paramour of Aidan Kearney. They had a domestic incident in which he was arrested and went and spent 60 days in jail. Those charges have been dropped. Why? Because in this, they got Lindsay Gattani gave over her cell phone willingly to Brian Tully. Brian Tully downloaded her entire phone, extracted all the information off of her phone, gave it over to Aidan Kearney's defense team. It got leaked to the internet. So anything and everything, all of Lindsay's personal information, etc., poof, out in the world. So Lindsay sued Michael Morrissey, the head of the district attorney's office, Ken Mello, Robert Cosgrove, Brian Tully. She sent a demand letter saying, I'm going to sue you because you violated my rights. So that other case got dismissed because now that Ken Mello and Robert Cosgrove are being sued, it's a conflict, right? They can no longer prosecute the case. Do they get another special prosecutor to come in? They didn't. They said there's nobody to prosecute this case. Done. So the defense is saying in these witness intimidation cases, Lindsay Gattani is a witness. Therefore, you're conflicted on this case too. So bye-bye, you have to go, Cosgrove. But does Cosgrove say that in here? No, 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 no. Why would we address that issue? No, we're just going to go on with some other stuff. Let's continue. To be sure, judge may permit a motion that has been heard or denied to be removed when substantial justice requires. Emphasis added. Oh, emphasis added. Thank you for that emphasis added. Such instances should be rare, however, lest said in a different context, judges would become Penelopes, forever engaged in unraveling the webs they wove. Okay, now you're just arguing why they can't bring this motion back up, but you don't address any of the specific issues that they address, like magic discovery has been found in a magic box somewhere. I wonder if there's like a magic box that like you open it up and poof, all this discovery comes out. Or I should say Trooper Michael Proctor's case, it was in a folder somewhere. Here it is magically. Here it is. We found it. No harm, no foul. Just your life is on the line. You could go to jail forever. No big whip. Renewal, however, is typically appropriate where new or additional grounds are alleged which could not reasonably have been known when the motion was originally filed. Duh! You're arguing their point right here. In Superior Court, a motion for reconsideration shall be based on one newly discovered evidence that could not be discovered through the exercise of due diligence before the original motion was filed. A change of relevant law, a particular and demonstrable error in the original ruling or decision. A motion of reconsideration shall otherwise raise no new grounds for relief not raised in the original motion or opposition, or shall not reiterate previously advanced arguments. Okay, so not only, if this is your case and the judge says, okay, nope, you did this before, you can't do it again, then they're also asking for an evidentiary hearing, which means everything comes out. Everything. They're going to tell them everything. So if you haven't watched the Karen Reed trial, Jen McCabe, who was one of the house guests inside 34 Fairview, had Carrie Roberts over at her house. And Carrie Roberts was on the phone with the police. And she was in one room and Jen McCabe was in another room. And Jen McCabe texted to their family group chat. She's telling them everything. So that's why I said that, because it's funny. A motion for reconsideration shall otherwise raise no new grounds for relief, nor raise the original motion or opposition, or shall not reiterate previously advanced arguments. The defendant's motion for reconsideration flouts each and every one of the three prerequisites, which may explain why he shrinks from honesty, labeling it as a motion for reconsideration. In his initial motion, the defendant did not attack, as he now does, any of the video evidence offered by the Commonwealth. For his present motion for reconsideration, he now claims that the prosecution and Detective Tully deceived the grand jury by grouping videos the Commonwealth offered as evidence of intent on a folder on the thumb drive exhibit labeled Intent, showing edited clips that allegedly deprived the grand jury of viewing Kearney's actual full episodes, many well over 2 hours long, and assigning titles to the edited clips that did not match the titles in Kearney's assigned the full episodes. Yeah. So so you're the juror of fact, right? If you're getting an edited video that says, I'm going to go harm someone, and that's not what the name of the title of the video is that misleading? If you only give certain clips of a video and don't give the full context of the video, does that paint a full picture to you? Are you, as a grand jury, are you going to go ahead and indict on these things that the prosecution has selectively put in for the grand jury to see instead of the full thing, even though they're 2 hours long? This is someone's life we're talking about. How can you skirt the issues? Although, as the Commonwealth will shortly develop, these arguments have been entirely waived by their omissions from the first MD. It first stoops to briefly address the substance of Kearney's new raised claims concerning the videos. Tully never testified that Kearney created the thumb drive folder labeled intent, and into which Tully placed videos showing Kearney's intent, and no reasonable juror would have drawn such an implausible inference. Moreover, the juries had available for their viewing the video clips themselves and could view them and draw their own inferences as to Kearney's intent. Tully never testified that Kearney created the thumb drive. Well, what does that imply? What's the implication there? Did he say that Kearney didn't make that thumb drive? Did Tully say that he created the thumb drive? Where is the confusion? Counsel used the term edited to describe the clips as artful, is falsely implying that the contents were somehow modified or distorted. Where that's so, one might expect the 88-page affidavit to offer examples of the edits, but there are none. And this is because the edits consist entirely of the exact clips of relevant content broadcast by Kearney. The only editing is selection. Yeah. The appropriate course, according to counsel, would have been to show the entire episode for each show, or by Mr. Kearney's account, over 50 hours of content. Presenting from any questions as to whether subjecting the grand jury to such an extended dose of Kearney's video would have violated the constitutional prohibition against cruel and he's saying that giving the full videos to the grand jury would constitute cruel and unusual punishment. Oh my gosh. I'm gonna write that down. Oh, oh my gosh. Oh my gosh. I'm crying so hard that my eyes are tearing up. I'm laughing so hard. Such a course would have been inserted confusing and irrelevant material, and doubtless would have generated additional defense arguments that Kearney was prejudiced because the Commonwealth presented evidence of other conduct for which it did not specifically request indictments. If one were to seriously entertain the defense's play the whole video argument, a useful way of thinking about it would be by analogy to the trial doctrine of verbal completeness, which holds that where the Commonwealth places into evidence passages from a defendant's statement that it believes support the charge, the defense may then put in such contemporaneous evidence from the same statement which contradict, modify, or otherwise throw light on the prosecution's passage. The rule is exhaustively discussed in Commonwealth v. Watson. In the context of admission of documents, defendants have insisted that the entire whole document or not part of it was competent. There is no such rule. And quoting United States versus Dennis, of course, the standards of grand jury presentations are less exacting than at trials. A grand jury is not bound by the rules of evidence that hold at trial. The grand jury hardly could have been misled by the titles Lieutenant Tully used to identify the excerpts he played for them, considering the specific examples which the defense singles out as misnamed and misleading episodes. Those titled by Tully as Trying to Destroy Colin Albert's Life, Life as Normal is Over, Impromptu Live 8/7/23, Alberts Should Be Afraid. All of those titles were taken from Kearney's exact words, which the grand jurors saw and heard him speak as to the YouTube clips were played, in which the court has exhibits at the defendant's previously McCarthy-Odell motion to dismiss. Footnote 2. Footnote 2. In trying to destroy Colin's life, Kearney begins by musing about whether Colin's aunt, Jill Daniels, whose photograph he displayed, has a crush on him, a proposition he modestly thought at first to be ridiculous. After asking his viewers to weigh in on the impromptu topic, he opines that it's wild because I'm like trying to put her godson nephew in jail and kind of destroying their life. But she also likes me? Like what? 2 comments. Daniels is not a witness in the Reed case, but as a relative of a witness. Kearney considers her fair game for humiliation. Second, Kearney implicitly states the goal of his behavior with respect to Colin destroy his life. Okay, I'm going to pause there for a second. So, tit for tat, right? The House defendants are going on the opposition saying XYZ, and they're allowed to say XYZ, right? It's their right. It's their First Amendment right. Maybe they're defending themselves. Maybe they're coming up with things that say, I wasn't in the house. Colin wasn't there. Again, there's been so many things that have come out from this trial, right? And so, how is this wrong? If Kearney's like, hey, your hat likes me, she's not a witness. So she's a relative of a witness. Is that witness intimidation? No, she's not a party to the trial. Okay. We're talking about the edited titles of his YouTube presentations. Tully was apparently in this thing, Tully took words from Kearney and made them the title of the videos, but that wasn't what the actual titles are. He edited the evidence. I'm sorry. That's what he did. And in life as normal is over. Kearney shares the screen with a photograph of one of his acolytes. One of his acolytes has snapped of Chris Albert when he was at. Okay, okay, that's left out. As the Commonwealth explained to this court on the previous go-round in episode 598, Life is Over Now, Kearney taunts Albert, suggesting that he will never be able to go anywhere in peace because there are turtle riders everywhere who will harass him and photograph him wherever he goes. It's only going to get worse from here. Although Chris Albert didn't personally kill John O'Keefe, he raised someone who did and was helping him to cover it up, he adds. Chris, I know where you guys were today. You were in Agawam, weren't you? I got pictures of you on my cell phone. I got people sending me pictures. You guys were at some sort of little league thing in Agawam. Alberts, McCabe's, all you people were there. So just you know that there will be no life as normal is over. And Albert should be afraid. Kearney assured his viewers that they had nothing to fear from the same Alberts who he routinely accused of being implicated in a murder. The jury saw and heard Kearney conclude, I'm certainly not afraid of Brian Albert or Colin Albert or any prejudice to the defendant Kearney himself was the author of. And damned not by a sinister manipulation by the Commonwealth, but of his own mouth. All of the above examples, chosen and singled out not by the Commonwealth, but by the defendant himself via the Betterow affidavit, are illustrated of the truth of Tully's statements that named the videos to accurately describes their content, often using the exact relevant phrases spoken to the defendant. You can't pick and choose. You can't pick and choose. You can't just take some things from one thing and put it somewhere else. That's not how this works. Also, some of Tully's titles for the excerpts were far more anodyne than the Kearney titles for the full episodes for which they were taken. Who cares? To pose to rhetoric questions if Tully's purpose was to use the excerpt titles to inflame the grand jury, would he really title the excerpt from episode 580, Elizabeth Proctor's Dumbest Wife Ever, Brian Albert opposition motion, to bland call to Elizabeth Proctor? Would he have toned down Kearney's drunken lardo Drunken lardo, Michael Morrissey declares war on turtle riders to response to D.A. Morrissey's statement? Doesn't matter. You changed the evidence. Sorry. But the court need not wade into any of the defendant's contentions about titling of the excerpts, because the defendant has waived the argument, failing to make his original McCarthy-Odell motion to dismiss. At the time he filed that motion, he obviously had available to him the full episode names that this time around has lovingly memorialized in a three-page chart in a row. He had all the relevant grand jury transcripts containing each and every word of Lieutenant Tully's, and he now calls to the court's attention, including the titles designating the clips played for the grand jury, which he previously ignored but now ooh, excoriates. He had copies of the grand jury exhibits, including each and every video played for the grand jury that he now references. No one knew better than the defendant himself what he had titled his original episodes and that they were lengthy, often well over 2 hours in length. But the other thing here you see that that is not stated in here is I believe, and you can correct me if I'm wrong, Kate Peter, who is a arch nemesis of Aidan Kearney, who was a former employee of his, uh, was taking these videos and giving them to Ken Mello and Brian Tully. And we believe, or it's alleged that she doctored things and gave it to Tully. So we're talking about a side witness. Remember, the people out to get Kearney are acting as agents for the prosecution to give evidence to the detective, Brian Tully. And did he take exactly what she had and presented it, or did he change it up? That's also an issue. It could not possibly have escaped. His intention that the Commonwealth played not the full videos, but pertinent excerpts that the Commonwealth placed on some of those exhibits in an electronic folder designated intent, which the defendant obviously knew he did not create, and that the names of the excerpts typically corresponded to their content, not to the titles he himself had given the full episodes. Nobody was better situated to make these observations than the defendant himself. Finally, even straining Charity to the point of believing Carney was oblivious to the obvious to the obvious at the time he filed the McCarthy-Odell motion, the Commonwealth's opposition to that motion clearly should have been altered him to the issue in time to raise it at oral argument before Judge Doolin. Attorney Betterow correctly surmises that undersigned counsel had been unaware that the excerpt titles came from Tully, not Kearney, relying on undersigned counsel did on the exhibits introduced before the grand jury. However, for whatever reason, undersigned counsel nevertheless did notice one retitling and scrupulous called it to the attention of the court in discussing the video excerpt confronting Jen McCabe at the lacrosse game. Undersigned counsel stated that apparently the title was assigned by the Commonwealth. The video comes from Turtle Boy Live broadcast entitled Asking Jennifer McCabe That Question. Does she know the answer? Oh, here we go. Kate Peters is entered into the world. Kate Peters' involvement as an informant in the investigation of Kearney's alleged crimes proves no substantial basis for reconsideration of this court's prior denial of the defendant McCarthy's Odell motion. Kearney acknowledged in passing existence of his prior motion to dismiss, but asserts that he filed it without access to undisclosed evidence, which he claims was important. The defense designates two such pieces of evidence. First, communications between Peter, Mello, Detective Tully, which was crucial, and if disclosed promptly, would have been included in support of the defense's motion to dismiss. Second, the previously discussed presentation to the grand jury of excerpts from Kearney broadcasts that were labeled by Tully. The defense claims that it learned for the first time on September 4, 2025, as fully demonstrated above, that the contention is risible. It is true, however, that since the previous defense motion to dismiss, the defense has acquired communications among Special Prosecutor Mello, Lieutenant Tully, and Miss Peter, and so has new evidence. There's new evidence. That being undisputed, the remaining legal question for this court is whether the significance of that evidence is such that substantial justice should dictate an undoing of Judge Doolin's previous denial of the defense motion to dismiss. It should not. There's a factual dispute that the court should resolve. The defendant paints Ms. Peter as a member of the prosecution team, indeed, the dominant player to whom Special Prosecutor Mello outsourced investigative work. There are text messages, and there are emails that will tell you otherwise. Per Betterow, Mello was supposedly aware that she edited Mr. Carney's content with her own editorial slant and bias and reviewed private links she sent him 2 days before the grand jury proceedings started. The implication of that latter assertions, apparently, is that Mello and Tully were spoon-fed maliciously edited clips by Miss Peter, which they then mindlessly regurgitated as a grand jury exhibits. That's what I said earlier. As Lieutenant Tully's affidavit demonstrates, that's not the case. Lieutenant Tully sometimes lies. Miss Peter was not part of the prosecution team, but a source of information among many sources. The primary source of information was the victims of Kearney's broadcasts, who complained about them to the Commonwealth. That's not a crime. Although, to be sure, Peter may also have brought some of that information to Mello or Tully's attention. In each instant, Tully went himself to the internet, viewed the alleged offending material, copied it if appropriate, and if presenting it to the grand jury, named it in the way that accurately identified its contents, usually using Kearney's own words as containing the excerpt. But I believe that it matches Kate Peters' stuff that she sent him. So did Tully edit the titles, or did he just copy paste what Kate Peter gave him? On the one hand, the defense is highly critical of the Commonwealth as ignorant or dismissive of Peter's woeful credibility. On the other, it never fails to adduce the slightest boast by Miss Peter as to her own importance to the investigation as credible. Yeah. The defendant's bald assertion that the Commonwealth employed Miss Peter to clip and edit and rename Kearney's episodes and then conceal the actual episodes and their accurate information from the grand jury consideration is outrageous and irresponsible untruth. But in two instances, the Commonwealth, of necessity, one minute you're saying this is irresponsible, but on the other hand, you're saying, well, we kind of did. We did actually do that. But in two incidences, the Commonwealth, out of necessity, did use the exact videos provided by Miss Peter because those videos were no longer up on the internet, allegedly because they had been removed. But both were wiretapping claims. One arose in connection with the alleged superstitious recording of Lindsay Gattani, which the defendant played on the internet broadcast. The evidence was the initial version was taken down and a second version substituted in which Kearney edited from the same other source an announcement that he was recording the conversation. Gattani's testimony corroborated that Kearney never told her the conversation was being recorded, i.e. the initial version, not the second, was genuine. The other, Peter recording, was introduced during the grand jury presentation involving Mr. Scanlon. Okay. Kearney is not being charged with wiretapping of Lindsay Gattani. He is being charged with witness intimidation. And trust me, if you thought that you can get him on wiretapping charges, you would have done it. Because you're out to get him. And so you would do anything that you can if you had evidence against him to put charges on him. At trial, a defendant might well contest the authenticity of these or any recordings, but here the Commonwealth had good faith basis for believing them to be accurate, based on the statements and testimony of the involved witness. Who, Kate Peter? Scanlon claimed that Kearney told him he wouldn't record their conversation. There was no impropriety in their introduction. He's not being charged with that, so why are we talking about it? Were the court to are you doing like a switcheroo when you're doing a magic trick? Oh, you don't see a ball? Oh, well, here's a ball. Were the court to conclude otherwise, however, the proper remedy would be the dismissal of the result tainted indictments. That is unnecessary. The Gattani indictment is not before this court. It was never a part of this court number in any case and has been null process. No prosecutor for unrelated reasons by the Norfolk DA's office. Neither is the Scanlon indictment before this court. For, as the defendant has complained repeatedly, the Commonwealth did not ask the grand jury to return one. So then why are you talking about it? As for the indictments actually before this court, to the extent that she and Mr. Kearney share a mutual loathing, as they clearly do, and to the extent to which she may desire to see him hurt, humiliated, and imprisoned, and she apparently does, the question for the court and ultimately a jury, should a trial judge permit counsel to go down that particular road? It is not the bias of any particular informant, but the reliability of the evidence. The Commonwealth's evidence before the grand jury consisted of videos indisputably made by Kearney documenting his own actions and the testimony of his victims as to their knowledge and for those actions and the impact they had on their lives. It matters not a whit who informed the Commonwealth of any particular video's existence. What matters is the authenticity of the evidence. Okay, well, you're saying one thing out of one side of your face and saying it out of the other side of your face. The authenticity of the evidence. Were the what was presented to the grand jury, was that authentic? That's the dispute right now. For all the relentless characterizations of Tully labeling of the video excerpts shown to the grand jury as improper, intentionally misrepresented, out of context, cherry picked snippets, prejudicially named, falsely named, misnamed, sliced and diced, cherry picked out of context, tricked the grand jury. Nowhere does the defendant point to even a single word of Kearney's in any video clip that has been altered or modified by the Commonwealth. Nowhere does it point a single instance where a word was omitted, altering a meaning, and nowhere does he represent that he did not create the videos of his own actions, his own words shown by the Commonwealth out of the grand jury. He does not make those representations because he cannot. At the end of the 30 pages of the Memorandum of Law, 88 pages of meandering argument mislabeled as an affidavit, and a host of exhibits, the defendant's contentions amount to nothing more than the sound of fury signifying nothing. Wow. This is 26 pages. We're at page 13. The Commonwealth has provided the defendant with an extensive discovery in this case. Whatever the problems or flaws in its production of discovery, there have been some. They fall far short of requiring a draconian sanction of dismissal of this case. Okay, so you admit that there have been some discovery issues. Again, no problem. Nothing to see here. No rights violated. Just continue on. Just continue. Let's convict him. The Commonwealth promptly provides the defense with extensive discovery as borne out of the items set forth in undersigned's counsel letter to Attorney Bradel, May 8th, 2024, as notable for its expression of the undersigned belief native to the retrospect that the discovery was then almost complete. Yeah, you lied. You said that the thing was complete. Remember, you gave him a thumb drive of like 40 some odd pages and like 30 of them were blank. And this discovery is complete, and yet we're still discovering things even to this day. This court should take note of discovery itemized in the letter, the subsequent discovery letter, June 13th, 2024, and indeed the Commonwealth's filed and documented responses to the defendant's previous discovery motions, and measures the veracity of the defendant's claim that since Mr. Kearney's 2023 indictment, the Commonwealth has exhibited breathtaking indifference to its constitutional and statutory obligations to disclose evidence to this defense. Duh. The discovery has continued since that time, and with the Commonwealth responding to the defense request and the defense in return finding problems with the discovery provided, alleging missing discovery, sometimes correctly so. Oh, so you admit it. And continuously generating new discovery requests and demanding further explanation of discovery already provided. Some of the Commonwealth's problems have been logistical, which are not the defendant's fault, but inform the realities of the production. What? I'm not making this up, people. I'm not making this up. Oh, I'm sorry. We've had technical difficulties, so we can't get that to you when we said that all the discovery was in. So you lied to the court in front of the judge and said, "Oh, all discovery's in. Oh, we're having difficulties. Sorry, my bad." By the way of background, the investigation into Kearney began May and June of 2023. Tully affidavit. Attorney Mello, a resident of Bristol County, was engaged as special prosecutor on or about September 2023. Oh, we're going to go into the story of Mr. Mello. 6 months later, March of 2024, the Norfolk District Attorney's Office recruited that undersigned to assist Mr. Mello with some legal research, writing, and similar tasks. Mello, however, proved to be gravely ill. Why did he take it on? And has been physically unable to appear in court, requiring the undersigned effective to assume full responsibility in the case. By the way, Mr. Mello is still on this case and hasn't recused himself. Just FYI. Mello, however, proved to be gravely ill. Okay, in point of fact, the undersigned has never been able to meet with Mr. Mello in person since undersigned counsel's entry of an appearance in any case against Mr. Kearney. And that's whose fault is that? If you, Cosgrove, get this case, I don't know when you got this case. We're in 2025 now. When did you get this case, Mr. Cosgrove, and that you weren't able to meet with the prior prosecutor to get the evidence? And yet you're going to court and saying you got all the discovery and everything? Is this what you're saying? Which counsel has largely been able to obtain discovery materials directly from the Norfolk District Attorney's Office. Some of the necessary materials have been in Mr. Mello's possession. That's not Aidan Kearney's fault. That's yours. And his ongoing health problems. Okay, we're making excuses. To return to the previously mentioned May 8th, 2024 discovery letter, the court will note that in addition to the discovery produced by undersigned counsel, it referenced discovery previously provided by Lieutenant Tully, given Mello's illness, then hoped to be transitory. Tully was employed in the prosecutor's normal role of providing discovery. Excuses, excuses, excuse me, hello, 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 hi, hi. We've entered into the excusatory phase right now where I'm just an old man. He's been playing this card, and I don't know how technology works. And, you know, it's not my fault, Your Honor, I didn't turn in my paperwork. Mr. Mello didn't give it to me. So, but like, can we still convict Aidan Kearney? Can we please, 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 please? Another difficulty with discovery in this case has been the ongoing nature of the defendant's conduct towards the alleged victims and witness. To reiterate just a few previously brought to the attention of this court and others, there was his online hope that Lieutenant Tully would die horribly along with his wife and children, charmingly coupled with Kearney's self-comparison with Jesus. His nose to the window antics and accusations in the form of questions at the Albert Pizza Shop captured by the security camera. Again, so you want to talk about wiretapping? Aidan was in front of D&E Pizza in Canton, which is owned by Chris Albert. He was out there with his friend making funny jokes and stuff like that. And he did not, there was a camera outside, but there was a camera inside that was recording everything that Kearney said. That's illegal wiretapping. Why isn't Chris Albert being charged with wiretapping? Why aren't you mentioning that we didn't charge Chris Albert with wiretapping? But yet Kearney is being charged with witness tampering against Colin because of that. Because Colin was in the back of the D&E Pizza and Kearney had no knowledge. Yet again, we just going to continue to put charges on the boy. Yep. Nothing to see here, Judge. Let's go ahead and just convict. Let's hurry up. Let's get this case moving and convict. His recent drive-by outside Cape Cod home of the witness Karen Reed's case. Oh my God, are you talking about when he drove past Brian Higgins' house in Cape Cod? Oh my God. So he's not allowed to drive anywhere. You're not allowed to drive past people's houses. There's no stay away order, right? Oh, I guess there is a stay away order, but oh, come on. And he wasn't driving. He wasn't driving, by the way. He was a passenger in the car. His discourse as to whether or not an officer's wife was blue because Kearney speculated she gave her husband oral sex. So what? Freedom of speech. He can say whatever the F he wants to. I'm not going to continue with that. That's just diatribe. As it did with the attack on the grand jury's presentation, the defense focused much of its criticism on the Commonwealth's provision of discovery concerning Kate Peter, which it claims supported his posture. Okay, I'm just gonna. I just can't anymore. Defendant has complained repeatedly that the phone texts of that evening between Gattani and Tully were not introduced in the subsequent copy of the download of her phone provided by the Commonwealth. Undersigned counsel explained why that was in the case in his letter to Attorney Bradel, telling him in a pertinent part, if there's data missing, that is because it was missing when the phone came into the Commonwealth's possession, custody, and control. Thus, we don't have it. The Commonwealth later secured the missing text. Oh my gosh. One minute you're saying, "Oh, we didn't have it, Your Honor. Oh, wait, we found it. Oh, we found it. It's in the missing file. Da, 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 da. This missing box of discovery." The Commonwealth later secured the missing texts with Tully by means of copying them from his cell phone. Why didn't you fucking do that in the fucking first place? Oh my God. Handed them to counsel in opening court during a hearing. Oh, hey, guess what? Guess what? By the way, look what we found. Look, Your Honor, we're complying. Look what we found. Here you go. No harm, no foul, right? What other magical discovery they're going to find, right? So, in sum, the defendant wishes to tell the jury that the Commonwealth engaged in a plot with Kate Peter and Gattani to make her a witness, then lure her to his apartment, provoke him to a criminal conduct, then arrest him so his bail could be revoked. They did that. So cunning were the alleged plotters that Miss Gattani studiously avoided any mention of their plot and its apparent progress when texting Tully. Nothing like "it worked. He's here now. Arrest him." Oddly, neither Tully nor any other officer was outside Gattani's apartment, waiting to burst in and arrest Kearney at the appropriate moment, and not incidentally protect Gattani from any harm. Equally oddly, right, because Gattani didn't report this. It was later on from somebody else that said, "Oh, you need to say this happened." She was being coerced into stating that Kearney had done something to her. Equally and oddly, Gattani never reported the incident to local police the following day. Yeah, a lapse that prompted her alleged conspirator, Tully, to make the call. Tully, this defense theory is Lincoln-esque, at least to the sense that Lincoln has been quoted like falsely as saying, "You can only fool some of the people some of the time and some of the people all the time." So yes, obviously the defendant is correct that the Commonwealth thinks little of this theory. All right. We're a little over an hour, and I'm going to have to put a pause on this. This is insane. Okay, so in conclusion, for the reasons set forth by the Commonwealth, the defendant's motion to dismiss is apparently incorporated in the Beddoe affidavit and should be denied, with the exception of the defendant's prayer to the defendant's prayer to disqualify Mello, which the court should take no action on, as that issue is moot. Oh my gosh. Oh my gosh, people. You can't make this up. Okay, I am not a lawyer, but I can clearly see through this. I cannot wait for the December 5th hearing. I cannot wait for them to go back and forth. I cannot wait to hear all of this reiteration again. I cannot wait to see Mr. Beddoe in action. I cannot wait to see how this is going to play out. And I cannot wait for the judge to be like, "What? What? This happened? No, no, no." Like, he's going to be dumbfounded because this is a new judge. He doesn't even know half of the information that's coming out. It is going to be wild. Now, I'm hoping and praying that this is what happens. I'm hoping that this judge is going to sit back and listen, and he's going to be somewhat relaxed like Doolin is, and let the party say the things, and that he's not going to interrupt, and he's going to let this play out. But who knows? All right, people. Uh, I had some good laughs. I hope you did too, because this is hilarious. So tomorrow is Turkey Day. I hope you and your family and friends or whoever you're celebrating with are having a wonderful time getting together. Remember, it is a reflection of peace and love and joy and just having fun with those and laughing and recalling memories, etc. So, have a good Turkey Day. Not going to stream tomorrow, but I'll probably come back on Friday. Maybe we'll go over the rest of this and see what the actual heck pops off. There's going to be no court. There's no court on Thursday and Friday, so who the heck knows? I hope you have a good one. See you on the next one. Thanks for joining me. Make sure you like and subscribe. I need to get to 50 by the end of this month, and we're close. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.